SJC-09264, Commonwealth versus Fernandez.
Mr. Cunha, you were better, we hope?
I'm sorry, Judge?
You were better?
Judge, I can't remember when I was that sick.
Really?
It was awful.
All right, well, welcome back.
Thank you very much.
You may proceed.
Thank you, Judge. On June 20th, 2002, three teenagers, one 14, two 16-year-olds, went from Boston to Brookline, where to talk to some girls was the testimony. And when there, they went to a playground where they tried to buy some marijuana, unsuccessfully. It's unclear exactly why, but then that group and the group that they encountered, who were a number of people, apparently it was a high school graduation party. There were four young men, including the victim, Mr. Hughes, who were all about 19 years old. And there were some young ladies there as well. A minor controversy, unclear why it was a controversy at all, but certainly a minor controversy became a death. And I'd suggest that one of the central factors here was the age of Mr. Fernandez. Approximately a week. Pardon me?
As it relates to both the Colleran factors and as it relates to the request for continuance for an expert?
It does, Judge. Yes, it does. At the time, approximately a week before trial, the trial counsel for Mr. Fernandez filed a motion asking for funds to have Mr. Fernandez examined on the basis of the then, I would suggest, not very well known evidence about adolescent brain development. This was 2 years before the Roper v. Simmons decision in the United States Supreme Court. The judge denied the motion. He denied the motion for a number of reasons, one of which was he said that it was too close to the trial date, but he also stated that he thought that, and I don't have the exact words here, and I apologize, particularly as I see the prior cases, their command of the record was, to me, impressive. But the judge, in effect, said he did not think that this was particularly helpful. It would have been particularly helpful evidence. And I'd suggest that that's absolutely wrong. You have a situation in which, at trial, the issue of premeditation was a real one. You had three witnesses who testified, and I believe we set out the citations to their testimony in footnote 12 on page 10 of our brief. That after this arguing back and forth, Mr. Fernandez, two people said, well, one person said that Mr. Curley said that he took a step at most and turned, and he said, Mr. Fernandez said.
Before you leave, I just want to focus
Judge.
on the timing for a second. So it's 3 days before trial?
I don't know. I know it was shortly before trial, Judge. I'm not sure.
So, I mean, and this is complicated, right? You're going to get an expert. We're talking about a fairly major delay, right? We're not talking about a 2-day delay. We're talking
No,
about,
we're not.
We're talking about basically putting it off the trial list, right? I mean,
You are. It's a Norfolk case. Norfolk, in my experience as a trial lawyer, is a lot more flexible in terms of its ability to schedule trials, as say compared to Suffolk. However, would it have meant a delay of a couple of months? I think that's a good assumption. Yes. So what we also have, if I could just finish, Judge, and I don't mean to interrupt you, but what we also have, though, is a child who had killed somebody and was going to trial with his life at stake. So the stakes were high in terms of whether or not he should have had all proofs in his favor.
Well, but what about the requirement that the judge have there be some kind of affidavit or something connecting things for the judge, rather than just a broad general, this might be a good area for me to pursue in discovery, in terms of research for trial, and I need an expert now. I mean, it's a little different.
I think the problem there, Judge, is that the request was to get somebody to analyze him, to develop the evidence. And I know in a coro what this court says. It has to be particularized. I'm actually very familiar with the coro. I was the trial lawyer. So I've been through that battle. Mm-hmm. However, I'd suggest that the fact of being 16 is enough to trigger the request that he be examined. This is not whether or not at that point there was admissible evidence that the trial counsel could have trotted in the expert from Harvard Medical School, and I believe she was also from McLean's, could have trotted her in and put her on the stand. We're not suggesting that's, particularly in light of Okoro, we're not suggesting that that's the case. The question is, was there enough, just on the basis of the age? And I don't think that there was any suggestion that that wasn't enough. What the judge said was he didn't think it would be particularly helpful.
That's not off. When you're dealing with a motion to continue on the eve of trial, whether it's a motion to continue because of a relationship with counsel, the Mello case is cited, not enough time to prepare for a retrial with new counsel. You have to balance what the reason is for the delay, and the language is measurably contribute to resolution of the case. So Judge Bornstein's faced with a last moment continuance, and he has to take that into account, impact on the judicial system, and all the other factors that we see in these cases, and also the importance of the testimony. And he can't read Commonwealth versus Okoro when he's when he's making that analysis. So I don't think that it's wrong.
I'm not suggesting that, Judge.
No, you're not. But what I'm saying is that he may not have precisely used the words from the cases, from Commonwealth versus Miles and Mello and all the other cases. He might not have used the precise words, but he got it pretty close. Materially contribute to resolution of the case in the balance.
Well, Judge, there was no question, by the time it got to trial, there was no question about who had shot Mr. Hughes. This was, like the last case, or at least one of the cases today, maybe a number of them, this was about what was the crime.
But her defense was, the defense, I guess she argued, was self-defense.
That's what she argued because she didn't have the alternative.
Well, I understand. You got to play the cards you're dealt, but
yeah,
it's frankly more than they had in the last case. But this is sort of the equivalent of a defense counsel Hail Mary with 3 days left to go, and we're going to say that Judge Borenstein, who, as we know, is not a bad judge for a defendant to appear before, abused his discretion in saying, I'm not going to postpone the trial to let you explore that possibility?
I'd say suggest, in fairness, let me just say this with respect to the trial judge. The science was not particularly, it certainly was not as well known now as it is now. However, there was a lot of documentation that was given to Judge Borenstein in support of the motion. So was there a specific affidavit with respect to Mr. Fernandez, as I think Justice Cypher was asking? No. But there was a lot of information to educate the judge, to tell him this is important. This can bear on, frankly, Judge, it could bear on premeditation. It could bear on the intent to kill. It could bear on any number of things. In fact, I can't think of one element of murder that this wouldn't bear on.
And counsel, is it too late now for a motion for new trial based on, putting aside standard of review questions in terms of what an expert could come up with at this
I'd suggest
point?
that it's absolutely too late. There's no doubt about it.
Because
And Frank, because
brain
he's,
would have
he's
changed?
31 years old at this point, or 32, I can't remember exactly. Frankly, by the time the post-trial litigation was over, there was a motion to reduce the verdict, and then there was a motion to reconsider. I think Roper was brought to Judge Borenstein's attention. That took 5 years. The trial itself was a year and a half, approximately, a little less, after the event. So that's another thing with respect to Judge Lowy. I know a year and a half is it's not inconsiderable, but in terms of a murder case, another few months was not a big deal in terms of a continuance, at least the way it's been practiced since I've been on the murder list since 1983. So I don't think that it was an outrageous thing to do. So let me just, if I could, Judge, if I just want to finish.
Okay, go ahead.
Okay, I want to finish. At this point, to go back, I don't, it's not my bailiwick, but I don't think it would be possible for anybody to say, we've examined him now, this is the way he was when he was 16 years old. And I suggest that even back when that post-trial litigation finished, he would have been 22 or 23 years old. It was too late then. What I am suggesting to you, Judge, is that yes, I think a new trial should be ordered, and if this case was being argued, a year after the verdict, it would have been appropriate. Now, at this point, I have to be frank. I think that this is a very strong contributing factor to 33E relief. Because as a practical matter, what is a new trial going to do? He can't, it's lost. The evidence is lost to him.
You don't have an ineffective assistance of counsel claim here.
Well, I think she did what she could.
But she waits till, I mean, if she presented this in a timely.
I'm not.
Sorry,
fearful,
if she.
I'm not fearful of bringing those claims.
No, but if she'd presented this, not on the eve of trial, but, in a timely way, it'd be a much harder case.
Absolutely, Judge. There's no doubt about that.
But you haven't brought an ineffective assistance.
But I credit what she said to the judge, which was she had just learned about it.
But what does that mean, just learned about it? Meaning she had just started doing her homework or just read about something? I mean, I just don't understand. I don't know what that means.
I've tried to actually put myself in her place in 2002, and I can't really, I quite frankly, I can't remember when I learned about this. It was pre-Roper, but it wasn't much pre-Roper. I can say, I would represent to the court that amongst the trial lawyers that I know who were trying murders then, this was not a subject that was well known.
Right.
So the fact that she learned about it at that point is hardly surprising.
But we know she thought of it, and then the question is.
I don't know how it came up.
Okay.
Yeah. So the answer is I can't answer your question, Judge.
So just to think about it a little bit more, had she been able to get what she needed at that time?
Yes.
And had the judge allowed the motion, are you positing there would have been a general brain scan, and then we would have images and be able to draw conclusions from that?
There's a number of different things that can be done. One of which is just to give standard psychological testing. I did represent Emmanuel Okoro at trial, and we did not have him get a brain scan. That is actually a pretty difficult thing to do when somebody's in custody. But he was given a battery of standard psychological testing to measure things like impulsivity, to measure things just to try to get a measure of the maturity of his his thinking and his thought processes.
Judge Borenstein almost anticipated Okoro and offered to incorporate some of these concepts as it related to self-defense, and I believe as it relates to the intents for malice into his jury instructions. So he didn't just deny the motion. He's measuring moments before trial how to deal with this and offers to incorporate some of this into final instructions.
But there's no meat on those bones, Judge. There's no evidence that backs it up. There's nobody that come in there and say who could say, sure, a 16-year-old can form an intent. Sure, a 16-year-old can premeditate, but it's not the same. They're under the influence of the amygdala and not really under the influence of the prefrontal cortex. That this is spontaneous. This is impulsivity. What did Mr. Fernandez say when he turned around? He didn't say, and you'll pardon the vulgarity, he didn't say "fuck you" and he shot him. He said "fuck this," he said "fuck this shit" or something like that. Which is an expression of exasperation, which is a childish reaction when you're turning around and you're shooting at somebody. It did not have that kind of anger, that kind of pointed to you. I'm shooting at you. Fuck you. That's not what was said. And that's why, Judge, I think that there was a question even at trial of premeditation. He turned and he fired. There wasn't a lot of thought involved.
Let's talk for a moment about the implications if we rule in your favor in this case. So a case like this is very hard to put back together.
Judge, I think it's impossible.
I mean, and oftentimes at the trial date, a continuance is the same as a not guilty. It's very hard for a DA to put these type of cases together twice. Very hard, which is a factor that the judge, who is not supposed to take a mechanical approach to this and look at the reasons for the continuance and the implications of the continuance, can take into account. So this lawyer's been on the case for quite a while, 15 months or so. So if on the eve of trial you can get a continuance, why would it not make sense strategically on the eve of trial to request a continuance when the DA puts the case together, because now you need to get an expert? I mean, why isn't this just going to make it impossible for Superior Court judges to manage the murder list? Because that's an undercurrent here, so why don't we talk about it?
I guess, Judge, your question seems to assume bad faith in terms of the defense lawyer who is an officer of the court, which I do not share. I can't imagine the lawyers I know who take this work on. It's hard work. It's not very well paid. It eats at your heart and it eats at your soul and your body. And to say that one of those lawyers is going to go to a judge and give him a line of BS.
Well, I think that's a really good point.
I just don't see it.
So I have to say, I think that's a compelling argument, and I agree with you. But at some point in time, the information is presented to the judge, and it's the eve of trial, and the judge has to manage the trial.
Absolutely.
I take your point, and I agree with your point. It's important to keep in mind, and I don't think that would happen either as a matter of strategy. But they're busy, too.
I understand that, Judge. Look, we're all human, right? Judge Borenstein as well, someone I know well, actually, is a human, and the fact is people can make mistakes. And they can make mistakes that are serious. And it's not personal. It doesn't bear upon somebody's quality as a judge. It bears on the quality of the decision that was made at that time, which was not a good one. He had enough information that was given to him from scientific literature by the trial lawyer, which should have said, uh-oh, this is real. And he didn't get it. He said, this is not going to be very valuable stuff. I think that's a judgment on the relevance is an error of law. He was wrong about how relevant it is, and he made a mistake. So I would suggest again that if we were in the posture of a year or two after the trial, I'd suggest that this would be a strong case for a new trial. We're not, and I recognize that. I can't come up here and say anything that, give him a new trial because this evidence is lost. And I see that my time is ticking down. I just would like to point out that in the instruction, and it's
Can I ask you one question?
Yes.
So say we accept your argument.
Yes.
And we wanted to exercise our 33E power.
Yes.
How would we do it without any evidence on this? I'm just trying to understand how would the
Well,
opinion read to you?
we lay out in the brief that every single one of the Colleran factors, all 5, and I hope to address some of those in the time that I had. We meet every single one of the Colleran factors. And I understand that 33E is a tough situation for this court because there is the desire to keep verdicts. That is a strong bulwark of our system. And there's a tension between that and 33E. But you do have 33E power. And so what I'm suggesting to you is that this is a very strong Colleran factor 33E case. Plus,
To do what?
it's got to reduce it to second degree.
If we do that, aren't we essentially saying we need to reduce every juvenile,
No, Judge, because this
demonstrate
is...
some degree of, sadly, we get a lot of these stupid, senseless, mindless killings, and the term, fuck this is not the first case I've heard of in which somebody before they shoot said basically, fuck this shit, and then shot somebody. So, doesn't this mean that in all those cases we got to drop it to murder too?
Well, I can't judge, I can't tell you whether the Colleran factors, every single one of them pertain in all of those cases. So that's part of the problem that I have in answering your question. But also, this is the circumstances I suspect are unique, where there was a specific request made for funds to get a adolescent brain expert and an evaluation of the defendant, and that is a very strong fact, and the denial of that, which I'd suggest was error, is a very strong addition to the Colleran factors. I doubt that exists in any other of these juvenile cases.
On this record, is there any evidence with regard to this particular defendant in terms of having any psychological history or anything else?
There was an affidavit that was filed by his mother in the post-trial litigation in which she talks. It's in the record appendix.
I'm referring to anything before Judge Borenstein that would indicate that this particular 16-year-old is different from another 16-year-old in terms of...
Well, it was a post-trial motion, but it was in front of Judge Borenstein.
No, I know, but I mean, at the time that he denied the motion...
Oh, at the time he denied it.
Did he have anything, was there any psychiatric history? Was there any indication of IEPs or of anything that would say this is a particularly psychologically troubled youth?
Not at that time.
Just one more question on the Colleran factors, if I could, please. So, do you think these facts really are a sudden affray or spontaneity? Because there's a number of steps before they get to this point. There's a back and forth, there's a back and forth, there's a back and forth.
But the reason it's spontaneous, Justice Lowy, is that there is, but if you'll pardon my using the same terms that we're talking about, it was really fuck you type stuff. They were just having a juvenile exchange of who are you and why are you here and why are you laughing at us, and so, pardon me?
From location to location.
No, in the first location there was no indication of hostility or aggression by anybody. It was in the second location. So yes, there was some protracted nature, I mean, probably over the course of like 5 minutes, but to the, back and forth between the two, the 3 younger Boston kids and the 4 older Brookline kids. But the act itself was clearly spontaneous. He was walking away, he turned, said what he said, and fired. That's spontaneous. I have a hard time imagining that in any spontaneity case that the spontaneousness is that somebody comes up and just says for some reason and shoots somebody. That's not the nature of what it is to be spontaneous, because it moved from words, and not even particularly bad words. I mean, there was this implication that maybe that we should have a fist fight between somebody who was at least 3 inches taller and 3 inches older with one of the youths, which they didn't think was all very fair. But the act itself was spontaneous. I think we lay it out fairly well in the brief, and I'm going to have to rely upon that since I am well over my time at this point. If you want me to go, I'll take all the time I can
I
get.
appreciate it. It's always a pleasure, but I think your time is up.
Thank you, Judge.
Ms. Alford?
Thank you, Your Honor. Pamela Alford for the Commonwealth. The Commonwealth today asks you to affirm the conviction for first-degree murder of the murderer of Perry Hughes, where the motion for funds and motion to eliminate to produce the juvenile brain expert was filed 3 days before trial, was unsupported by affidavit, necessitated a continuance, offered no evidence how it would apply to the defendant's specific circumstances. The judge did not abuse his discretion. And I would like to answer some of the questions that Justice Kafker asked about the record. It is in the Commonwealth's addendum, and it is at, particularly starting at addendum at 54. Defense counsel talks about that this discussion has happened in the past 5 years. Defense counsel had asked for a continuance the week before, and when at the time, she doesn't present this as a continuance, but it's clear that a continuance is necessitated, and when Judge Borenstein basically confronts her with that, she doesn't dispute it. Going back to then addendum at 58, she talks about that she was researching this in the last week. And I think that's a critical factor. This is not about indigency or a motion for funds. Justice Borenstein, in one of the post-trial motions, orders on the motion to reduce the verdict, noted that the defendant had gotten funds in April of 2003 for, I believe, an investigator and a ballistics expert. There was no reason that a motion could not have been filed on this, either a motion to do the brain scan or a motion just to evaluate him. And I think that's a critical factor, that that all the defendant was looking for here was to use this, what she termed as new technology, to do a brain scan. There was nothing, the person she wanted to bring on was a researcher about juvenile brains and cognitive functions. There was nothing tying it to the juvenile specific circumstances, and there was nothing to prevent the defense counsel in April 2003 from asking for an evaluation. Even to do a scan, it was 15 or 16 months later after the time of the murder.
Can I ask about the specifics, just so I understand it better? I take it the argument is essentially he's 16 years and 10 months old, and he's gotten into this kind of stupid, altercation, and for no reason he shoots this guy. I take it it's sort of a generic based on youth, in these circumstances, meaning in these factual circumstances where the kids don't know each other, they're having a beef over, stupid who sits on a car kind of beef. That's not enough, then, I take it. You need to show that this specific youth has brain development issues as opposed to what a 16-year-old's brain is.
Yes.
You need to bring me up to speed on that.
3 points on that.
Because it seems like this is a classic teenage idiocy thing, and I'm just trying to understand, is that?
I think that's exactly right, and I would respectfully suggest that I don't think the murder happened for no reason. I think it happened for no good reason. But I think the defendant was upset that he got disrespected, that he felt disrespected, and that's why he walked up to the victim, taking out a gun, cocking it, after he had turned away. Route 9 was in front of him. His friend said there was nothing preventing him with the loud mouthing. The defendant walking away with his friends, turns around, cocks the gun, walks back to the victim, and shoots him through the chest.
No, and I understand. I'm just trying to, and I get all the delay issues, but it seems like this is the only defense they've got. There's no real self-defense here because he's walking away and then he walks back. And then I'm a little confused by why the judge decides that he's going to give them instruction without evidence that sort of supports this idea.
He doesn't say without evidence. What the judge says is, we'll see how the evidence comes in. The judge was cognizant of the age of the defendant. And to address Your Honor's comment about teenage idiocy, I suggest in more formal terms, what we're talking about here is the idea that's been developed in the law that juveniles, while they make decisions to kill people, make bad decisions, this is not a deliberate premeditation intent issue. This is a moral culpability issue that has been addressed in Roper and Miller and Dachenko. In this juvenile, I suggest that issue, the generic issue of age and culpability to what he did to the victim, is addressed on a sentencing basis, and this victim, defendant...
But we've gone further in Okoro and the other case. We've gone beyond sentencing, right? We now, we're past Dachenko. We're into how it impacts intent, right?
Exactly, and I think Okoro and Brown are the controlling cases here. And I think Judge Borenstein really honed in on this issue back in 2003, before either one. In Okoro...
Can I just frame the question? I don't mean to cut you off, and I apologize, but so if this were well done, if 2 months before trial, the trial defense counsel put in all this evidence and said, look, in these factual circumstances, we're dealing with a classic, case of, undeveloped response or whatever. Do they still lose? I get that 3 days before trial is a whole different story, but I'm having trouble finding, I don't know about how much specific you need to put in on the particular child. And maybe you do, I just don't know.
I think Okoro says that you do. In Okoro, they had school records. He had already had a psychological evaluation done. There was nothing preventing counsel from doing a traditional psychological evaluation of the defendant if she thought that was necessary well before this event. And Judge Borenstein gives the defendant's motion due credence and says, I've read the... and this is at addendum 58. He says, Ms. Capicchio, let me say this. I am familiar with the studies, and no study says all juveniles develop in the same way, and all of them are subject to the potential risks of dangers. Defense counsel, absolutely, Your Honor. Number one. Number two, they also have margins of error. Number three, I have no information before me in support of your motion that says anything about whether Mr. Fernandez has been tested falls within or without the group of juveniles that might be subject to these studies and to this testimony. I have nothing to support that. And if you look at what defense counsel appended to their motion in limine, they talk about that the category of juveniles that might be more susceptible in these to react badly in these high-stress situations have triggers. So Judge Borenstein really, I suggest, took close credence at the factual support of what was produced. And then he denies it for a number of reasons. He denies it.
Where in Okoro, by the way, just educate me, where in Okoro does it talk about what you specifically need from the individual? Is that handy? If it's not, I'll go read it myself.
I suggest, I'm looking at Commonwealth versus Brown, which distinguishes Okoro. So it's going to be right around Commonwealth Okoro, 471 Mass 51, the discussion about the juvenile brain issue and what was presented was 65 and 66. And in that case, it was actually the defendant suggesting that the defense expert should go further. And there, Dr. Cunha in Okoro was allowed to testify about the general development of juvenile brain brain function and how it would, and basically to educate the jury of how it would apply to that defendant's particular circumstances. If you then look at Commonwealth versus Brown, and Commonwealth versus Brown, let me get the site for you, Your Honor.
I can read it. I don't mean to derail you.
Commonwealth versus Brown says there they wanted a jury instruction that that juveniles had a diminished capacity compared to adults, and they said no. They said, one, that goes further than what this court disallowed in Okoro, and comparably to Okoro, there was no factual development of the record. There could have been, and Judge Borenstein really hones in on this point, there could have been factual development of the record in a number of ways, including asking the defendant's friends who testified, including bringing in his school records, doing a traditional psychological evaluation. This wasn't a defense that the defense counsel was pursuing. And the Commonwealth does suggest there were strategic reasons for that. If you look at the motion in limine, just before this discussion about juvenile brains, the defense counsel wanted to keep out evidence that the defendant had used a gun before. And the prosecution's argument was, well, we need to see how this motion in limine goes, because if there's going to be an issue that you're going to raise lack of intent, then I might want to bring in that he knows how to use a weapon. And Judge Borenstein says, well, I'm allowing the motion. It may have been without prejudice. I'm not entirely sure, but he says, defense counsel, you're on notice that if you start talking about that the defendant was just handed a gun and is surprised and doesn't know what's going on and is confused, then I'm going to at least allow the prosecutor to make the proffer that I get to rebut that by saying he knows how to he knows what a firearm does, he knows how to use a firearm. Defense counsel never asked the judge for jury instructions based on the defendant's youth. The defense counsel never raises lack of intent, even just based on age. Defense counsel went purely on self-defense. The judge, faced with this motion in limine that quite frankly was speculative. There was no tie-in between what pictures of the juvenile's brain 15 months after the offense was going to be able to say about the juvenile's, that particular juvenile's intent. Not that juvenile brains are less developed than adult brains, but that particular juvenile brains. And if you look at one of the articles that the defense counsel, appellate defense counsel cites, Mary Beckham, Crime, Culpability in the Adolescent Brain, they talk about, this was a 2004 article, and a neuroscientist, they're talking about the debate, says too little data exists to conduct behavior to brain structure, and imaging is far from diagnostic. We couldn't do a scan on a kid and decide if they should be tried as an adult. 3 days before, at any point, I suggest a motion in limine to do a brain expert needed more than was presented to the judge.
Along those lines, let's see if we can just do the analysis. So first of all, is it an abuse of discretion standard similar to the motions to continue for having new counsel the day of or shortly before trial? Is that the same analysis with the request for the continuance and an expert?
The request, the implicit request for the motion that would have necessitated continuance is an abuse of discretion standard.
Okay, so we apply those
Yes.
Miles types abuse of discretion cases.
Yes.
Okay. Then, when we do that and we look at the reasons why the Commonwealth would be objecting to a continuance and those concerns and the administration of justice, and then we look at whether the expert testimony would measurably contribute to the defense. When Judge Bornstein's doing that analysis, do we impute 2017 into that analysis, or is it 2003?
We don't. We impute what was put before the motion judge or the trial judge at the time.
Sure, I understand that, but now we have what's before Judge Bornstein in 2003. Do we analyze it based on as if he's reading it in 2018, or do we look at it as if he's reading it in 2003?
We look at it as if he was reading at 2003. The Judge Borenstein can't fairly said to have abused his discretion in acting on a motion for continuance based on 14 years of development in the field, and I think a critical point is the development in the field, and I recognize Justice Kafker's point that Okoro talks about. Does talk about intent, but the great development in the field, it goes to sentencing and moral culpability. And even if you look at the transcript of the motion to reduce the verdict, the defense counsel says, well, we've just had this Roper case, and it's the same studies that that I had put before you. The argument here, I suggest, was nothing more than that this was a juvenile. And the law has subsequently taken that into consideration. So I do agree that Justice Borenstein did not abuse his discretion in denying the motion for funds and denying the motion for motion limine. The defendant is entitled to a life with parole sentence because he was 16 years and 10 months old.
Your view is, in determining the abuse of discretion, Commonwealth versus Okoro and Brown have no impact.
They don't, except to the extent that Okoro shows the prescience of the judge for trying to tie this in specifically to the defendant. I suggest this case is controlled by Commonwealth versus Penn, which was also a juvenile case. And looking, actually, before I get to Penn, one last point on whether there can be an evaluation now. I don't disagree as to the trial issue, but I think it is a very important point to note that because he was 16 years and 10 months old, and because he is now entitled to a life with parole sentence under Dachenko, under Dachenko 2, he's entitled to make a case that he gets an expert to talk about, at parole, to talk about the factors that may have affected him back when he committed the offense, as to it relates to his culpability. And I suggest, so this court has already addressed that issue as to how juveniles as a category, how this court looks at their moral culpability. As to 33E review, I suggest...
That's what I wanted to ask you about next, exactly that issue. So now we take Okoro and Brown, and as we look at the Colleran factors, look at 33 review, do you take into account Okoro and Brown and what we know about the juvenile brain now and ruling on that?
I think you take into account both what was presented before the judge in 2003. I do think that you compare it against the cases today, and in particular, the Commonwealth would assert you compare it with Commonwealth versus Penn. Commonwealth versus Penn is also a juvenile case, and I suggest very similar facts. The defendant's friend wanted to find his ex-girlfriend, who I believe was dating or friends with the victim. The defendant's friend and the victim get into a fight. At some point, the evidence is that the friend hands the defendant a gun. A witness sees an individual inferred to be the defendant chasing after the victim. They stop. The victim turns. The defendant walks. Who's inferred to be the defendant shoots him. And what this court held is where there wasn't a deficiency in the evidence, and the defendant was entitled to the benefit of Dachenko, 33E review is not warranted, and I suggest the same thing is here. The Commonwealth's assertions that premeditation was strong here.
But again, that may well be right, I don't know, but when we look at it, and you're seeing whether deliberate premeditation is mitigated under the Colleran factors, do we take into account what we know in 2018? And I believe that your view is that we would.
I think you take into what the cases say. Yes or no, Your Honor, I believe it's a more nuanced answer. I believe you take into what the cases say about what cases are available are appropriate for 33E review. And I disagree that Colleran gives, is the only factors. They list, Colleran lists factors that this case has used. But I do think that in terms of looking at the evidence of premeditation, you look at what was presented at trial. And here what was presented at trial was that both the defendant's friends wanted to walk away. And while this might be a vulgar, and I think the defense counsel used puerile exchange, the gist of the Brookline group, the victim's friends, was leave, we want you to go. The defendant's friends wanted to go. They were headed towards Route 9 with nothing in front of them when the defendant turned around, said what he said, pulled out and cocked a weapon, shot the defendant at, I'd say, either arm's length or 3 feet away, ran away laughing, bragged about it later to his friend Keely Washington by saying, I'm the #1 clapper. This is not, and if you look at Rodriguez, another case where 33E review was denied, this is not a case where it was a minor controversy or a sudden affray. The defendant was the only one using violence, and for these reasons, the Commonwealth asserts 33E review is not appropriate here.
All right, thank you.
Thank you.
Court, all rise.